The candles had been burning since before dawn. In a stone chamber somewhere in the Loire Valley, the year approximately 1140, a girl of 12 sits very still on the edge of a bed she does not recognize. The mattress smells of rushes and tallow. Cold air presses in through a window too high to see from. Somewhere below, men are still drinking. She can hear the cups, the laughter, the particular sound of agreement between people who have gotten what they wanted. On the floor beside her feet sits a single object, a wooden chest bound in iron, carrying everything she was permitted to bring from the house she will never sleep in again. The lock on the chest bears her father's seal. She does not have the key. She will not need it. From this morning forward, everything she owns belongs to someone else. Before the week is out, you will understand exactly how this arrangement was designed, not by accident, not by custom alone, but by law, by church doctrine, by the deliberate architecture of institutions that had every reason to keep it precisely this way. This is the history that the wedding celebrations were always meant to obscure. Now, let's go back to the beginning. If you are interested in histories buried inside records and archives, stories that institutions tried to finalize before anyone could ask questions, consider subscribing. There is more of this to come. To understand what marriage meant for women in medieval Europe, you have to first understand what property meant, because for most of this period, the two words describe the same thing. Picture a Carolingian scribal hall, sometime in the 9th century. A monk bends over a sheet of parchment by tallow light. He is copying a land transfer. The grant lists fields, a mill, a portion of river rights, and then, without any change in handwriting, without any pause in the rhythm of the sentence, a daughter. Her name appears once. Her age is not recorded. The transaction moves on. The Roman legal tradition, which did not vanish when Rome did, had always treated women as a category of person requiring management, not protection, management. The distinction matters. Protection implies vulnerability in need of defense. Management implies a resource in need of direction. Roman patria potestas, the power of the father, extended over daughters, wives, and daughters-in-law in ways that a modern reader would recognize less as family law and more as asset law. A woman's legal personality was, in most circumstances, subsumed by that of the nearest male relative. This was not a failure of Roman law. It was, from Rome's perspective, the law working exactly as intended. The Germanic kingdoms that replaced Rome brought their own systems, the Frankish, the Visigothic, the Anglo-Saxon, and while the specific terms varied, the structural logic did not. A woman passed from the mundium of her father, the legal guardianship that controlled her body, her labor, and her contractual capacity, to the mundium of her husband. The transfer was formalized. It was written down. It required witnesses. It generated documents. What it did not require, in most jurisdictions for most of this period, was her. The records that survive from the Carolingian period, land grants, marriage contracts, donation charters, show this transaction in its clearest form. A daughter appears in these documents as a line item. She is listed alongside cattle, vineyards, and silver plate. She has a value assigned to her: the dose, the dowry, the maritagium, the mourning gift. These figures were negotiated with care. The parties to the negotiation were, overwhelmingly, men. The church complicated this picture, but not always in the ways the church later claimed. Imagine a young woman standing before a church door in northern France around 1160. The priest asks, in the presence of witnesses, whether she takes this man of her own free will. She says yes. What the record does not show, what no record was designed to show, is the hand on her elbow, the faces of her brothers standing just behind her, the understanding, built into every hour of her life since childhood, of what the alternative would cost. By the 12th century, canon lawyers had been arguing for decades about what made a marriage valid. The most influential answer came from the theologian and legal thinker Peter Lombard, whose sentences, written around 1150, formalized a doctrine that would shape Catholic marriage law for centuries. Consent, he argued, was the essential act. Not consummation, not parental approval, not the transfer of property. Consent, freely given by both parties, was what made a marriage real in the eyes of God and therefore in the eyes of the Church. This sounds at first reading like progress. It was, in certain narrow circumstances, a tool that some women used to resist arrangements made without them. The canonist Gratian, writing around the same time, recorded cases in which women had appealed to church courts on grounds that their consent had been obtained under duress. Some of these appeals succeeded. But the gap between legal doctrine and lived reality was, in medieval Europe, almost always vast, and this gap was not an oversight. It was maintained, reproduced, and enforced by the very institutions that had written the doctrine in the first place. Consider what consent meant in practice for a girl of 12, or 14, or 16, whose entire world had been organized since birth around the expectation of this transfer. She had been educated, if she had been educated at all, in the skills of household management and spiritual obedience. She had been told by every authority available to her, priest, father, mother, older women who had survived the same passage, that a good marriage was a duty, a grace, an honor. To refuse was not simply to inconvenience her family. To refuse was to sin. It was ingratitude toward God, who had placed her in this station. It was disobedience toward her father, who held her mundium, and whose authority was, in the theological language of the period, a reflection of divine order. When the church court asked whether her consent had been freely given, she said yes. Of course she said yes. The remaining records, the donation charters, the land grants, the occasional letter that escaped the bonfire, suggest that historians are still debating the precise frequency of explicit coercion versus what we might now call structural coercion. But the distinction may matter less than it first appears. A consent given inside a system designed to make refusal unthinkable is not the same thing as a consent given freely. The architecture of medieval marriage understood this, even if it never said so aloud. In the aristocratic households of northern France, England, and the Holy Roman Empire, the political function of marriage was not incidental. It was the point. Daughters were, to use the language that contemporary chroniclers actually used, pacis instrumenta, instruments of peace. The phrase appears in sources ranging from monastic histories to royal correspondence, and it was not intended as a condemnation. It was a description of a diplomatic function that everyone involved considered entirely rational. A marriage between the daughter of one lord and the son of another created an alliance. It created mutual interest. It created, in theory, a reason not to go to war, or, if war came anyway, a more complicated set of loyalties to navigate. The practice ran from the highest levels of European power downward through every tier of the feudal structure. When William the Conqueror arranged the marriage of his daughter Adela to Stephen of Blois in 1080, the union was not primarily about Adela. It was about Normandy, England, and a network of continental obligations that required careful binding. When Eleanor of Aquitaine was married at around 15 to the French king Louis VII in 1137, her biographers, writing long after the fact, would emphasize her intelligence, her cultural influence, her eventual agency. What the documents of 1137 emphasize is the land, Aquitaine, the extraordinary territorial inheritance that her father William X had died leaving behind him, and which needed, immediately, a protector capable of holding it. Eleanor was the instrument by which Aquitaine was transferred. This is not a retrospective cynicism. It is what the sources say. The instrument in this case eventually learned to read the music. Eleanor's subsequent history, the annulment, the immediate remarriage to Henry II of England, the courts of love at Poitiers, the imprisonment that followed her rebellion against that same husband, is well documented and endlessly analyzed. What is less often noted is how precisely her life traced the outer limits of what the system permitted. She used every tool available: royal blood, territorial wealth, the particular leverage that came from being the mother of heirs. She pushed those limits further than almost any other woman of her century, and she still spent 16 years imprisoned by her husband, held in comfortable but absolute confinement at Winchester and Salisbury, because the system that had made her powerful had also transferred her mundium, her legal guardianship in all things, from her father to her husband, and had given him the right to determine where she lived. This is what the outer edge of medieval female agency looked like. For women without Eleanor's wealth, without her bloodline, without her political inheritance, the edges were much closer in. Below the aristocracy, the mechanics were different. The scale was smaller. The documents are thinner on the ground, but the structure was identical. In the towns and villages of medieval England, France, and Germany, marriage negotiations for the daughters of craftsmen, merchants, and minor freeholders followed the same essential logic as those conducted in royal courts. A daughter was a transferable asset. Her labor, her reproductive capacity, her social connections, and her potential inheritance were all factors in the calculation. The negotiation happened between families, between guilds, between neighbors who had known each other for generations. The daughter was present for the betrothal ceremony. She was dressed for it. She was expected to smile. Court records from English ecclesiastical courts in the 13th and 14th centuries, records that survive in the collections of York and Canterbury, occasionally preserve cases in which women attempted to contest marriage arrangements. A woman named Agnes appears in one such record from the York Cause Papers, sometime in the mid-13th century. The precise details of her case have been summarized by later scholars rather than fully transcribed, and the original documents have suffered from time in ways that make complete reconstruction difficult. What the record appears to show is a woman arguing that the man she had been contracted to was not the man she had agreed to marry, that the betrothal had been made in her name by her father without her knowledge. The court's response was careful. It was procedurally attentive. It took testimony from multiple witnesses. It ruled against her. The ruling was not cruelty. It was consistency. This is the moment where the full weight of the system becomes visible. Not in its violence, which was real and documented, but in its ordinariness. The church court that ruled against Agnes was not composed of men who hated her. It was composed of trained lawyers applying a coherent body of doctrine with genuine attention to its internal logic. The problem was not the lawyers. The problem was what the logic was built to protect. This was not an aberration. This was the procedure. Every step had a name. Every name had a precedent. Every precedent had a clerk who recorded it, a judge who cited it, and an institution that depended on it remaining exactly as it was. The system did not need villains. It had paperwork. Canon law on marriage, as it developed through the 12th and 13th centuries, balanced two competing interests: the spiritual autonomy of the individual soul, which required consent, and the social stability of the property order, which required that marriages produce clear legal consequences for inheritance, legitimacy, and alliance. Where these two interests conflicted, and they conflicted constantly, the courts had to choose. The surviving records suggest that, in the majority of documented cases involving property-bearing families, stability won. The doctrine of consent remained on the books. It was real law. It could be, and occasionally was, invoked successfully. But the conditions required to invoke it successfully, independent witnesses, financial resources to pursue an appeal, freedom from the immediate household of the men whose arrangement was being contested, were conditions that most women lacked precisely because of the same system that was supposedly protecting them. There was a specific category of woman for whom the machinery operated with particular efficiency: the widow. A widow in medieval Europe occupied a position of extraordinary legal ambiguity. On the one hand, she was, in many jurisdictions, released from male guardianship upon the death of her husband. Under English common law, as it developed from the 12th century onward, a widow was entitled to her dower, 1/3 of her husband's estate, held for her lifetime. She could, in theory, conduct business. She could hold property. She could sue and be sued. She existed, briefly, as a legal person. This made her, immediately, a target. The Crown, in particular, developed a systematic interest in the remarriage of wealthy widows. In England, the practice of selling wardships and marriage rights, the right to determine whom a widow or a minor heir would marry, became a significant source of royal revenue from the late 11th century onward. The pipe rolls, the annual accounts of royal finances that survive in remarkable completeness from the 12th century, are full of entries recording payments made by men for the right to marry a specific widow or to prevent a specific widow from being married to someone else. The widow's own preference appears in these entries very rarely. When it does, it is usually in the form of a payment she made herself, to the Crown, for the right not to be remarried against her will. Magna Carta, in 1215, included a clause specifically addressing this. No widow, it stated, should be compelled to marry as long as she wished to live without a husband, provided she gave security not to marry without royal consent. The clause is often cited as an early protection of female autonomy. Read it again. She could choose not to remarry, but she could not choose whom to marry without asking permission first. The great abbesses of the 11th and 12th centuries, Hildegard of Bingen, Heloise, the women who headed the double monasteries of early medieval England, are sometimes presented as evidence that the Church offered women a genuine alternative to this system. In a narrow sense, this is true. The convent was a real space. For women with sufficient family resources to endow a religious house, or to pay the entry price of a major one, it offered literacy, administrative authority, intellectual engagement, and a life not organized around producing heirs. Hildegard of Bingen wrote theology, medicine, music, and political correspondence with popes and emperors. Her authority was real. But the convent was also a managed solution to a specific social problem. Daughters who could not be advantageously married, because the family lacked the dowry, because there were too many of them, because a particular daughter was considered unlikely to survive the demands of repeated pregnancy, could be placed in religious life instead. The decision was, again, made by the family. The daughter's vocation was, in many cases, assumed rather than discovered. The records of disputes between women who claimed religious vocation and families who wanted them back for strategic marriages fill the registers of medieval papal correspondence. A letter preserved in the Vatican archives, its date debated among scholars but generally placed in the mid-12th century, appears to record a case in which a young woman who had taken preliminary vows at a small Rhineland convent was recalled by her father following the death of her intended husband and the sudden availability of a more valuable match. She appealed to the local bishop. The bishop wrote to Rome.
Rome wrote back with careful procedural instructions. What happened next is not recorded in the surviving documents.
She is 23 years old. She has been married once, briefly, to a man who died in a military campaign before she could produce an heir. She is childless. Her dower is modest. Her father is alive. She is a woman of the minor nobility. Call her by the composite name that later historical summaries suggest, though no single document preserves this precise convergence of details. She is somewhere in the mid-13th century, in a household she cannot leave, in a situation she cannot name aloud, watching a negotiation she was not invited to join. Her family has been conducting discussions about a second marriage for approximately 8 months. She has not been asked. Her father is alive, which means her mundium has reverted to him. In legal terms, she does not exist as a party to this negotiation. She is its subject. She has, however, been observed. She knows this because the behavior of the household around her has changed in precise and telling ways. She is no longer permitted to correspond directly with her sister in the next county. A servant she trusted was replaced without explanation. Her confessor, the priest to whom she disclosed, in the privacy of sacramental confession, her fears about the proposed match, was transferred to another parish 3 weeks after she confided in him. She is not imprisoned. She is not in chains. But every opening through which her resistance could have organized itself has been quietly, efficiently closed. When the betrothal contract is signed, her signature appears on it. The question of whether this constitutes consent is not a modern one. It was asked at the time, by canonists, by theologians, by the occasional papal letter that engaged, genuinely, with the problem of structural coercion. The most honest of these texts acknowledged what they could not resolve, that the conditions necessary for free consent were rarely present, that the Church's doctrine and the Church's practice were in tension, and that the tension served certain interests more than others. A 12th century canonist whose gloss survives in a Parisian legal manuscript, the attribution is disputed and the translation necessarily approximate, appears to have written something to the effect that consent given under conditions of complete dependence was, strictly speaking, consent of the body only, and not of the soul. He appears to have written this in the margin of a section on valid marriage. He appears to have added no further commentary. The main text remained unchanged. That marginalia sat unread in its Parisian manuscript for decades, perhaps longer. The system it quietly condemned continued to operate, generation after generation, producing the same outcomes with the same efficiency. But systems that run long enough eventually produce their own evidence. The cracks do not always stay hidden. By the 14th and 15th centuries, those cracks had become visible in the record. The Paston Letters, a collection of correspondence from a Norfolk gentry family in 15th century England, surviving in unusual completeness, contain a series of exchanges that illuminate the interior of this machinery in extraordinary detail. Among them are letters involving a young woman named Marjorie Paston, who, in the early 1470s, contracted a secret betrothal to Richard Cal, the family's estate manager. Richard Cal was competent, loyal, and absolutely socially unacceptable as a match for a daughter of the Paston family. When the betrothal became known, the family's response was organized, sustained, and systematic. Marjorie was separated from Cal. She was subjected to repeated interrogations by family members, by the family's allies, and eventually by the Bishop of Norwich himself, who examined her in open court on the question of whether the betrothal had been made with genuine intent to be bound. She said yes. She maintained this under sustained pressure from her own mother, who told her, in words preserved in the letters, that if she continued to hold to this position, she would be no daughter of hers. The bishop ruled the betrothal valid. The Church's doctrine of consent, in this case, held. Marjorie married Richard Cow. Her family refused to receive her for the rest of her life. This outcome is frequently cited as evidence that women could resist the system, and this is true, within limits that Marjorie's story itself defines. She had, by accident, stumbled into a configuration of evidence that satisfied the canon law standard. A betrothal made in words of present tense, before witnesses, with demonstrable intent. The Church's doctrine protected her. But consider what the protection cost. She was 20, approximately. She lost her family. She was cut from the social network that defined her status, her safety, and her material security. She disappears almost entirely from the surviving historical record after her marriage. A woman who had generated some of the most vivid writing in the entire Paston collection becomes, suddenly, a blank, a name without entries. The system did not imprison her. It simply made her invisible. Consider a woman in London, sometime in the 1380s. Her husband has died. She has run his cloth business for 3 years, negotiating with suppliers, managing apprentices, signing for deliveries. She is competent. She is known. She has, in every practical sense, been a merchant. Then she remarries. On the morning after her wedding, she walks into the counting house where she has worked for 3 years. The ledger is on the table. The ink is dry. The apprentices are waiting. And she no longer has the legal authority to touch any of it. Late medieval and early modern legal commentators, particularly those writing in the tradition of English common law, began, gradually, to articulate what the practice had long already established, that a wife, upon marriage, ceased to exist as a separate legal person. The doctrine was called Coverture. It held that a woman's legal identity was, upon marriage, subsumed into that of her husband. She could not own property independently. She could not enter into contracts. She could not sue or be sued in her own name. She could not, without her husband's permission, conduct any transaction with legal consequence. The legal theorist Henry de Bracton, writing in the mid-13th century, described this condition with the kind of procedural clarity that makes it genuinely difficult to read as anything other than what it was. A wife, he wrote, paraphrasing rather than quoting directly from the surviving text, occupied a position structurally similar to that of a ward or a minor, legally present, legally considered, legally protected, and legally incapable of acting for herself. The word Bracton used for this condition was sub-potestate, under power. The condition lasted, in English law, in most of its essential features until the Married Women's Property Acts of 1870 and 1882. It lasted that long because it worked. This is the thing that the history of medieval marriage makes visible once you look at it clearly enough. The system was not broken. It was not a failure of good intentions. It was a highly functional mechanism for achieving specific ends: the consolidation of property, the management of political alliance, the reproduction of social hierarchy, and it achieved those ends with remarkable consistency across 6 centuries and several distinct legal cultures. The women who moved through it were not, in the main, unique victims of exceptional cruelty. They were subject to a structure that had been designed, maintained, and reproduced by institutions, church, crown, feudal lordship, common law, that found the structure useful. When the structure produced suffering, that suffering was processed as a side effect. It was documented, if it was documented at all, in the language of the acceptable, transferred, settled, provided for, married according to her station, a line in a ledger, a name entered and closed. The records that survive tend to preserve the transaction. They are thinner on the experience. What remains, when you look closely enough, tends to come from the margins. A woman's name scratched into a convent wall. A letter that was not destroyed, possibly because the person who should have destroyed it did not read it carefully enough, in which someone, the hand is unidentified, describes a marriage night in terms that the main body of the surviving correspondence never directly addresses, and which subsequent archivists labeled simply as miscellaneous, personal, undated. A will from a wealthy London merchant's wife in the early 15th century that leaves specific personal objects, a ring, a book of hours, a piece of embroidered cloth, to women named as friends in language that suggests something more than formal acquaintance. A network of women, maintained carefully across decades, who appear in no other document. A notation in the margin of a 13th century legal manuscript, in a hand different from the main text, next to the section on a husband's right to physically correct his wife, that consists of a single Latin word, iniquum, unjust. No name, no further record. Someone read the law and wrote one word and stopped. The history of these centuries is full of structures that justified themselves as natural, as divine, as simply the way things worked. And that turned out, on longer inspection, to have been choices made by specific people in specific circumstances to benefit specific interests. The marriage law of medieval Europe was one of them. It was designed by men with legal training, sanctioned by an institution with theological authority, enforced by a property order with material interest in its continuation, and explained to the women inside it as the will of God. Most of those women never wrote anything that survived. The ones who did rarely wrote directly about this. The archive is organized in most places around the transactions, the contracts, the charters, the court records, and not around the experience of the people being transacted. But the margins remain, the walls remain, the single words in different ink remain. And when you sit with those traces long enough, a question begins to form that has no comfortable answer. The mechanisms that turned women into political instruments, the doctrine, the law, the economic logic, the institutional incentives, did not require anyone involved to believe they were doing harm. They required only that enough people, in enough positions of authority, found the arrangement useful enough to maintain. The question is not whether that could happen again. The question is what it looks like when it already is, and what we are calling it this time.